All right, guys, we're going to be talking about the attorneys on retainer common mistakes for self defense. And these things closely relate to Colorado laws. So we're going to go through what they're saying, and then we're going to relate it to laws. I'm also going to talk about how attorneys on retainer in their product and what you should be looking for to make your decision on whether to go with attorneys on retainer or the other guys, right? So I encourage you, first of all, to make your decision wisely, and I also encourage you to look at their contract and look at the other guy's contract. I know finding time between family and work and other projects and possibly even hobbies is hard, but you should do it, especially if you conceal carry every day for the purposes of self-defense. So let's go ahead and get started.
At any time, if you have any questions, go ahead, put them in the chat, and our team will flash them on the screen. Before we get started, I wanted to remind everyone that Mark and I are both licensed in Arizona. He is also licensed in Hawaii. So we will not be doing many state-specific questions, but just generally discussing the common mistakes in self-defense.
Okay, like she said, there's not gonna be any state-specific stuff in here. It's just very general. I'm going to relate that to Colorado. So if you live in Colorado, this is going to be very important for you to understand.
Today. We also will not be discussing regulatory questions. As a reminder, this live stream does not constitute legal advice, and it does not establish an attorney-client relationship. But now that we've gone past that disclaimer, I want to kick it off to Mark. Welcome to the live stream.
Yeah, it's great to be here. I guess this is the Attorneys on Retainer live stream. Take two. You gotta be, you gotta be ready for technical difficulties. Life throws you curveballs sometimes, and you just gotta be ready to deal with them. So let's get right into it. Common mistakes. There are a lot of mistakes. Talk about the first one, Rachel. Get us started.
Yes, a very common mistake is that people use force too quickly. We see this a lot, and there's many times that people use force too quickly. Sometimes they're not facing an imminent threat. Sometimes the threat is just mere words without something else. And this is really important.
Okay, mere words without something else. You'll hear in a minute that they're going to talk about those mere words. It could be just about anything, and to include racial slurs, okay? If somebody calls somebody an N-word, let's say, that alone does not give you the right or the legal authority to defend oneself, okay? It has to be words with action.
Example I give sometimes is that imagine if someone approached you and said, hey, I'm going to shoot you in 10 minutes. So you have a 10-minute warning. That might feel like a real threat. It might feel very scary. And that person might really intend to shoot you in 10 minutes. However, that is not an imminent threat. At that point, if you were to pull out a firearm and defend yourself, you would not be justified under the law.
If you own a gun.
So this is USCCA, of course. And if you don't know, they dropped a lady called, her name I think it was Kelly Giles, and they basically dropped her from their program after she defended herself against her husband who stands above her. And anyway, go check that out. It's a very sad story, but it's also probably going to get a happy ending, right? Because the Louisiana Supreme Court actually mentioned that this seems like a self-defense incident, and they remanded it back down to the lower court. So it's a good thing.
Definitely have a problem there. This is an example that I've used as I've been speaking at the Crossroads of the West Gun Show for the last 20 or so years. I've often said, hey, if you one of you guys out there gets a little rowdy and says, you know what, I'm going to punch you in the face. I'm going to go to the bathroom first, and as soon as I come back, I'm going to punch you in the face. I say, raise your hand if you can take action now. And some people raise their hand. They say, a threat has been made. But the right answer is you got to wait until the person comes back from the bathroom. You know, reminds me this happens so often. We really don't have to reach back very.
Okay, on this one, I know Mark is saying, you got to wait until the guy comes back from the bathroom to have that immediate threat or imminency. But honestly, I think a prosecutor could argue that the one guy warned the other that they're going to come back and shoot him in the face if in 10 minutes, for example. And maybe that's enough to not have imminency. I don't know, right? So remember, we want to avoid the situation. We want to deter and then take action if we need to. I'm not a lawyer, obviously. Mark is. Now, the other thing could be, well, I have a right to be in that location. Even if somebody does say, I'm going to shoot you in the face in 10 minutes, I still would, if there's a credible threat for somebody shooting you in the face, let's say in 10 minutes in this scenario, I would just leave the area. I would just avoid this situation altogether, okay? Obviously, if there's like alcohol involved and all that stuff, it's going to be a little bit different, nuanced, but you get my gist.
Far to think of a real world example here. I took a strike force call very, very recently, and it was a situation where a person pulled their phone.
Okay, to clarify what the strike force is, so attorneys on retainer has a strike force. The strike force is those individuals that are going to spring in the action to make sure that you're covered when you call them. Okay, so let's say Dave Williams calls AOR, says, hey, I just did X, Y, and Z. I need legal advice. Well, you establish that attorney-client relationship right then and there, okay? And then you're connected to a lawyer on their law firm, okay? The law firm is Attorneys for Freedom Law Firm, and that attorney-client privilege is very important, in my point of view, for your legal defense, okay? So whatever you say to them doesn't matter when it comes to anybody trying to get that information, because they cannot give it to the court freely or anyone else. It has to stay between you and the lawyer. That's it. That's it. So that's very important, because here in a little while we're going to talk about keeping your mouth shut if there was a self-defense incident. Okay, so here we go.
In response to a person making threats. And the person wasn't really very close. It was really just words only. There were no weapons involved. There was nothing like that. And I said, look, it's always good advice to keep your mouth shut. We always advise that. But especially in this case, because, if you say what happened, you're handing the prosecutor a charge right there. The first thing they're going to seize on is a lack of imminency. That's really the key here, right?
Okay, they're going to hit on this a little bit later, but you heard them. Just keep your mouth shut when you are involuntarily interacting with the law enforcement. Okay, so we have to remember the Miranda rights, okay? They specify that anything you say can and will, big letters, I'm talking about big letters, okay? And will, all caps, be used against you, again, all caps, against you in the court of law, okay? So anything you say can and will be used against you in the court of law. It doesn't say it will be used for you. Understand that? So whatever you say, the prosecutor is going to use that against you. It doesn't matter what it is. If you say anything at all to police officers, guess what? The prosecuting attorney will use that against you. Period. Okay? Full stop.
In order to use self-defense, whether it's ordinary physical force or deadly physical force, any kind of force, if you're going to claim self-defense, the threat against which you are acting has to be right now. It's got to be imminent. So you really got to think about that, especially in the case.
Okay, notice this. They're talking about physical force and deadly physical force. Okay, so really understand this. Okay, the AOR program protects you in your defense of self, either using deadly physical force or physical force, but it has to be in good faith, which means you can't just go punch somebody in the face and then say, oh, I was defending myself, right? No, it has to be in good faith. So that's one of the criteria that they have. The others, you have to be charged with crime and you have to be an AOR member. Those are the three things that you have to have in order to be covered through the AOR program when you're talking about self-defense.
Thinking about pulling out a firearm, right? We all know you got to be dealing with a serious threat of death or serious physical injury, but it's got to be right now. Pull out that firearm too quickly, you just bought yourself a very serious prosecution. And it was interesting.
Okay, so here in Colorado, we had an individual up in Aurora who had used deadly physical force against a couple teenagers who were trying to steal his vehicle, and we haven't even talked about defense of property. Okay, but I'm going to spoiler alert: you cannot use deadly physical force to defend your property. That's just the bottom line. You can't do it. So don't do it.
I said to the person, look, I think you blew it, so keep your mouth shut. We're still going to defend you. You don't have to get it right. As long as you intended to act in self-defense, we got your back. The whole team is going to represent you. And I could hear this.
All right, so this is very important, guys. Like, you need to understand this, okay? Now, when we're talking about this, what is in the head of someone? Okay, Mark Victor and Andy Marcantel are the lead persons for Attorneys on Retainer, Attorneys for Freedom Law Firm, and the Risk Retention Group, right? So there's like a trifecta going on here. I can explain that in a little while. But they are the only ones, they being Attorneys on Retainer Law Firm, are the only ones who get to determine whether you are covered or not, okay? And remember, there's three things that have to happen. You have to be an AOR member. Of course, you have to pay the fee. That's with anywhere you go, okay? And then you have to be able to reasonably assert self-defense in good faith, meaning you didn't just go and do this all willy-nilly and punch somebody in the face or murder somebody or something like that. And you have to be charged with a crime or reasonably or likely charged with a crime. So those three things, if those three things are met, you're going to be covered for self-defense when it comes to the AOR program. And if you like the sound of that, use my link below and get coverage today.
Of relief on the other side of the phone because she knew she had blown it by pulling out the firearm a little too quickly, but I wanted to assure her we got your back nonetheless.
Exactly. And then what about another scenario? What if someone came up to you, Mark, and said,
okay, so I know I keep pausing it, but here's the deal, man. You have to listen to this. Listen to what Mark is saying, right? This guy is genuine. I can just tell these things. This guy is genuine. So he's literally saying, look, we have your back. And he's saying he heard a sigh of relief. Imagine for a second that you were doing your daily duties, whatever they are, okay? Somebody attacks you. You defend yourself with physical force or deadly physical force. You know that the police are coming. You know that you could possibly be charged with a crime. Because you don't understand the laws. You don't understand what to do. You're scared. You would be scared. It doesn't matter who you are. Even if you're a police officer, okay? Because police officers get charged all the time with doing something they weren't supposed to do in the moment. So, okay, so if you're a police officer and listen to this pertains to you too. There's 100% chance that you're going to be scared or at least frightened that you're going to be charged and potentially go to jail. Okay, So, what kind of relief do you think there would be if you know that somebody who knows the system in and out is going to be there to protect you from going to jail? All right. Now, obviously, lawyers don't win all the time, but having a lawyer that is pro Second Amendment, that is pro self defense, that is pro freedom in your corner should give you peace of mind. But you have to be an AOR member in order for that to happen. Again, use my link today.
Some really rude things, some things you didn't like, and they were, being kind of mean to you. What would you do then?
What would I do? I'd probably just smile and say, I feel bad for you, man. We're all on the planet a short time. Enjoy your life. Move on. One thing I wouldn't do is start throwing punches, right? People who understand self-defense, and this hopefully is all our AOR clients, they know about the mere words doctrine, right? They know no matter what somebody says, no matter how offensive, it doesn't matter if they said something terrible about your spouse or your religion or your favorite sports team or whatever, no matter how offensive it is. Look, this is free speech, right? We're living in a free country. People get to say whatever ridiculous.
And of your race. Now, I know that the black population doesn't like to hear the N-word, and I get that. But if somebody calls you the N-word, let's say I said that. Let's say I said, hey, you are an N, right? That doesn't give you the right to shoot me. That also doesn't give you the right to punch me in the face. Now, if I said something, and we'll get into this in a minute, you'll see. If I said something like, hey, you're an N, and I'm going to shoot you. And then I have an action with that, like I'm going to go grab a firearm, for example. Okay, that gives you every right to do what you need to do to defend yourself from serious bodily injury and or death, okay? So that's just the bottom line, right? If somebody calls you a racial slur, doesn't matter if it's, hey, you honky, hey, you N-word, hey, you whatever, WAP, whatever it is, okay? That doesn't give you the right to punch that person in the face or to shoot them, okay?
Things they want to say. If you're claiming you acted in self-defense because somebody said something you didn't like, you're definitely going to be in the wrong. Now, keep in mind, you can contrast that with words plus some action. And so that's one of the reasons I tell people to just shut up, right? There have been cases that we've had over the years where I said, why did you hit them? Well, they said such an offensive thing. I said, that's it? Really? And they say, well, I think so. Well, was the person walking towards you as they were saying it? Yeah, maybe. Were their fists like this? Maybe. Okay, now we got something to chew on. It's one of the reasons you keep your big mouth shut. So anyways, bottom line, don't ever use physical force if all you are responding to are mere words. That is never going to be self-defense anywhere.
That's
okay. So again, not to beat this dead horse, but sometimes words invoke an emotional response. If you are responding with emotion in the moment, you're likely not going to be responding well to any situation. That doesn't exclude all the other situations that could invoke emotional response, okay? So just the best thing is to stay calm. Take a deep breath and avoid the situation, okay? Yeah, that person might be a racist bigot and they may need and may deserve to get punched in the face, but are you willing to go to jail for it? That is the question.
needs to be some realistic threat of deadly physical force, or in the case of an ordinary physical force defense, an ordinary physical force threat, in order for you to then respond with your own force.
Yeah, you don't have to wait until somebody punches you in the face. Self-defense, doesn't require you to have to wait, but it's got to be an imminent threat. It's got to be right there upon you, because what the law says in such a case, if you've got time, if it's not imminent, look, you got to get out of there. And some states have duty to retreat in any event, even if it is imminent, which, fortunately, there's a minority of states. But in other places, lots of times someone will say, I'm going to do this or that. I'm going to go drive to my house and get a gun or something. You got to go to court and get an order of protection in such a case, or do something else. You don't get to preemptively use self-defense unless the threat is right there upon you. We use the word imminent in the law.
And let's talk about duty to retreat. So, like you said, most states do not have a duty to retreat, but...
Okay, so now we're going to talk about Colorado. We do not have a duty to retreat in this state. So, and you'll hear in a minute that even though there is no duty to retreat, you should find safe alternatives other than physical force or deadly physical force. And that may be retreating, okay? That may be retreating. And that will probably be the likely thing that you should do to prevent yourself from being prosecuted with a crime, okay? So remember, if you pull your firearm or you hit somebody, if there's something like that, then you may be charged with a crime. And if you are charged with a crime, now you have a bigger issue other than somebody facing you and saying, let's say racial slurs or, whatever. So just, even though there's no duty to retreat, you should probably try to retreat from the situation.
Do. Now, some attorneys argue that there's a little bit of a paradox to the duty to retreat doctrine, that if you're in a situation where you have the duty to retreat, if it really is an imminent scenario, then you can't possibly safely retreat if you're really facing an imminent threat of deadly physical force. However, you might...
Okay, so if you can retreat, let's say, because it's not imminent, maybe you foresee what's going on and you can retreat, then you should retreat. But the minute it becomes imminent and you decide to use physical force or deadly physical force, you should be able to explain that to, obviously, your lawyer, potentially a judge and a jury. Okay, so you have to kind of put yourself in that mindset. If I use deadly physical force or physical force right now, a year and a half down the road, 2 years down the road, I may have to talk to a jury of my peers and tell them exactly what happened on that day, right? So keep that in mind.
Contemplate some situations where a threat is imminent and you can safely retreat. And in those states, if you have that ability to safely retreat, if you do not do so, you will be facing a serious prosecution.
Yeah, I mean, it's there's a lot to talk about here. First off, in all the states that have a duty to retreat, you never have to retreat if you are in your home, right? So we call that the castle doctrine, right?
Okay, so it's Colorado specific, and I want to hit this really hard, the nail on the head. I want to really drive it home, okay? So, and I'm paraphrasing here, but the law basically says you can use any force necessary to include, but not limited to, deadly physical force to protect your home from intruders, okay? And you shall, it does say that, you shall not be criminally or civilly liable. So what does that mean? If somebody enters into your home uninvited and you shoot them in the face, you are completely justified in doing so. It doesn't matter why they're there. They are there uninvited, and you have the absolute, you can have absolute safety within your home. Okay, so I'm not saying you should do that. I'm saying that's what the law says. Now remember, if they're in your home and you have the ability to tell them, hey, get the hell out of my house, I'm calling 911, and you are prepared to, do what's necessary to protect your home, that might be a better option for you, right? If you call 911 and you say, hey, I'm on 911 right now, currently, get the flipping hell out of my house. And if they do not leave your house, you are definitely going to be 100% and then some justified in doing what is necessary to protect yourself. So, again, if there's a way to avoid this situation altogether, we can avoid the situation altogether. And instead of jumping to something that is going to potentially land us in jail.
Your castle, you don't have to retreat from your castle. Some states will extend that further and say you don't have to retreat. These are, remember, only the duty to retreat states. They'll say you don't have a duty to retreat maybe at work or maybe in a vehicle. You have to check the state you're in. Most states don't have such a duty. But it's true. I've had this conversation with an...
So that brings me to, hey, the nationwide program that they offer, I believe it's like $25 a month. For a family plan, I believe it's like $35 a month per person. Or maybe it's the other way around. Maybe it's $35 a month for an individual and $25 a month per person. So $50 a month for, let's say, a married couple. Okay? The nationwide program is a great program. Here's why. Because, well, first of all, you're not going to know all the damn laws in your state, right? You're not going to know that. You're definitely not going to know what is the nuances of the courts and all that stuff. So that's 100% not going to happen. Okay, you don't know all those things for sure. Okay, but you're definitely not going to know, even more so, all 50 states and their self-defense laws. You're not going to know that, right? So attorneys on retainer, what they'll do is they'll find a lawyer in your state and they will work through them. And that lawyer is going to have a lot more experience to defend you. And they're going to use that lawyer to basically what's called pro hac vice. And basically the lawyer in your state, whatever state you're in, for example, I'm in Colorado. I have an AOR membership. If something was to happen, I call AOR. They're going to find a lawyer here in the state, and that lawyer is going to be well-versed in the laws. And they're not only going to pick a lawyer that's well-versed in the laws, they're actually going to pick a lawyer that they believe is going to be pro-Second Amendment, pro-self-defense, pro-freedom, okay? They're not going to pick somebody who's just like, fly-by-night kind of person. You can pick your own lawyer, but honestly, I would advise against it. Like, do you know lawyers? Do you know if they're pro-Second Amendment, pro-self-defense, pro-freedom? No, they might just be in it for the money. So me personally, I would love for them to pick my lawyer because they understand the game and I need them to play chess and I don't need to be playing checkers. Okay.
County attorney. I've also had the conversation with a currently serving Supreme Court justice, and I've said, do you ever see a situation where you can retreat in...
All right, so he knows on some kind of personal basis a currently sitting Supreme Court justice. He didn't say the name, of course, like, why would he? But that just kind of shows you the people that you're dealing with here, okay? So again, Mark and Andy, they're the head of this whole thing, and they're taking responsibility for a lot of stuff. So these guys are taking responsibility for this, and they're putting their law firm on the line. They're basically doing everything to piss off the industry because they're coming at it from a different angle. And it's a good angle. And if you're not on the program yet, you should probably look into it.
Safety, and you're still facing an imminent threat of death or serious physical injury. It's sort of hard to think of that type of a situation, right? Because in these states where you have a duty to retreat, it's not under all circumstances. It's only if you can do so in complete safety. But if you can retreat in complete safety, how are you facing an imminent threat of death or serious physical injury, or even in the case of ordinary self-defense, an ordinary threat? So it's sort of hard to envision, and maybe somebody out there can come up with such a circumstance, but it's never arisen in my career that I can think of a time where the threat was imminent and you could still retreat in complete safety.
So this scenario is pretty unlikely to come up based on our experience, but if you are one of those people in that rare type of situation, then you would have to retreat first if you are in a duty to retreat state. Now, the next common mistake I wanted to talk about is the aggressor doctrine. So what if you were the aggressor in a self-defense situation? So let's say you started it. If you were the aggressor and started attacking someone else, you do not then have the right to self-defense. However, there are some times where you can reclaim that right to self-defense.
Yeah, a good rule of thumb here is don't be an aggressor and you won't have to worry about the aggressor doctrine.
I like that.
Yeah, I think there's no reason you should ever be an aggressor, right?
Okay, so I'm gonna expand upon this. If you are carrying a firearm, specifically, you should definitely avoid all confrontations that could turn into a situation where you have to use your firearm. You 100% should. So, if you are that type A person that is very proud of themselves, let's say, and you're carrying a firearm to protect yourself, which you should, or your family or whatever, and you have a tendency to not back down from a situation, you should probably rethink what you're doing, okay? Because when you pull your firearm out, you have to assume, I said this earlier, you have to assume that you're going to be charged with a crime. And being charged with a crime means there's a lot of other things that's going to have to happen in order for you to either be convicted or acquitted. The gentleman, I use that term loosely. The man who shot those teenagers up in Aurora for allegedly trying to steal his vehicle. It took 2 whole years for his case to be finalized. 2 whole years. Now I want to ask you something here. Even if you're acquitted, you have to ask yourself, is 2 whole years of legal battles worth it to not swallow pride? That's basically the big thing, right? You might have to swallow your pride. And if you're carrying a firearm, you should be willing to swallow your pride immediately, right? Just leave it alone, okay? Because you do not want to be prosecuted. You do not want to be charged, okay? So let's continue.
But if you are an aggressor, there may come a point where you say, look, I've had enough. I am now going to retreat. I'm going to stop. I'm going to withdraw. And very important for the aggressor doctrine, I'm going to communicate that to the other person. If you don't communicate that, then they don't understand that the burden is on you to communicate that. So you imagine a situation where an aggressor, someone has started a fight. They said, you know what? I don't like the look on your face, and I'm going to start a fight with you. And you get into a fight. And now they decide, the fight's not exactly going as I had planned. I think I've had enough. You got to withdraw. And you got to say, okay, dude, I've had enough. I'm out. And then if the other person continues to advance against you, now at least you have a good argument that you have regained your right to self-defense. Another way that this can come up, that does sometimes come up, imagine you're an aggressor in a fist fight. And you've started a fist fight, and it's, imagine both parties are the same size. It's a very evenly matched fight.
Okay. He brings up a good point. Like, what if there are no guns involved? Maybe you have a gun on you, but now you're in a fist fight. You're the aggressor for the fist fight, and the gun falls out of your holster or whatever, even though you didn't intend to use that firearm, that could still be used against you, right? So again, just don't be an aggressor. Basically, don't be a dick, right? Don't be a dick, and you should be okay. All right. Try to avoid, then deter, and then if you have to, take action.
The person pulls out a firearm. Okay, well now they might be, it seems they're using excessive force there, right? This is disproportional, probably a bad use of that firearm. You may have an argument here that you've regained your right to self-defense because now this person has sort of upped the ante by wrongfully or disproportionately using deadly physical force in response to mere ordinary physical force. You got to be very careful. As a good rule of thumb, if you're acting in self-defense, use the least amount of force that is reasonably necessary to repel that imminent threat.
And then another thing I wanted to talk about is the display of a firearm. Some people think just displaying your firearm is a safe way to go in all situations. Oh, they're not going to charge me if all I'm doing is a simple display. However, if you're not facing a serious threat or an imminent threat of physical force or deadly physical force, you do not get to display your firearm. You just don't. You actually have to have that threat. And you can be charged with a crime if you display your firearm. And it can sometimes surprise people the type of crime they can be charged with. Even if you do not fire your gun, you can be charged with something like aggravated assault just for pointing your gun at someone else.
It's amazing how many people do not understand.
All right, so I'm going to give you a story here. A buddy of mine, we're talking about the surprise of the charge that can be brought against you when you look at what actually happened. So a buddy of mine, he, in fact, you can go ahead and see the video. We have an interview. It worked out well for him, right? But it took 18 months for him to get a positive outcome. Okay, so keep that in mind. Basically, he had an accidental discharge. It went through the wall of his closet. It ricocheted off the roof of his garage, and then it went and hit his neighbor's house. Okay, so in Colorado, if you knowingly or with criminal negligence discharge a firearm into a dwelling, that is a felony. Okay. Now, there's a similar charge that is a misdemeanor, okay, but it has nothing to do with firing into the dwelling. It just has, an accidental discharge, let's say, or knowingly and recklessly just firing a firearm, right, without the actual going into a dwelling, for example. So you have this felony charge and you have this misdemeanor charge. The prosecution charged him with a felony. I want you to understand how serious that is. He was in his closet with his firearm, actually getting ready to do a class with me. He wanted to clean his firearm, so he's trying to clear it. He makes a mistake, has a discharge. It goes through a wall, which, by the way, he can't see. There's no windows in his closet, of course. Like, I don't know what closet there would be a window. Through the wall, and then goes and hits the roof of his garage, ricochets off of that roof, and then hits his neighbor's house. And then he's charged with a felony. That is just a slight example of the level of charges that could be brought against a person, even if they didn't have the intent to do what the thing is that they did. That's pretty damn serious. And the prosecuting attorney and attorney's office, they don't give a shit about you. They don't care. They don't care about you. All they care about is getting a win. So they charge him with the highest crime they possibly could. And then he ended up taking a plea deal down to the misdemeanor. And he got unsupervised probation, which basically means don't get in trouble with the law. So it was the best possible outcome he could get without getting an acquittal. But again, he took the misdemeanor charge because it had taken 18 months to get to this point. 18 months. So again, if you're charged with a crime of anything, of any nature, you are going to be, at the very bare minimum, sitting around not knowing what your fate's going to be for a minimum of a year. That's my interpretation anyway.
Point, I can't even count the number of people who have come into my office charged with aggravated assault, sat down on the chair and said, Mark, this is going to be the easiest case for you. And I said, why is that? And they said, well, I never even touched anybody, and I'm charged with aggravated assault. Imagine how they must feel when I say, you don't have to actually touch anybody. You just intend to put somebody in fear of an imminent touching. That's generally enough in most places to constitute an assault.
Did you hear that? You just have to give the other person enough reasonable suspicion that you intend to harm them. That's it. 4.
And if you do that with a fire...
Aggravated assault is what he said. So if you didn't hear that, it's aggravated assault. So if you pull your firearm, even if you don't point it at him, you could be charged with aggravated assault with a deadly weapon. It's pretty freaking serious, man. So, again, if you're carrying a firearm every day, you definitely need to know what you're up against if you pull that firearm. And you need to know what an imminent threat is.
You're looking at an aggravated assault. That's going to be mandatory prison in so many places. So, a finer point here, right? Again, use the least amount of force. If you're thinking about the firearm and you can start by saying, look, dude, I got a gun, back off. That's all you do. If that gets the job done, do that. Don't pull it out and point it at somebody. If you can say, look, I got a gun, and you got to show the gun, fine. If you just got to pull it out and don't point it at anybody, fine. If you got to point it at somebody...
Now, I'm going to disagree with Mark here a little bit. I don't think you should ever mention that you have a firearm. I just don't think that. I think that could escalate situations more than it can deter situations, okay? So, because maybe they call your bluff, for example. And then now what? I'm sure a savvy prosecutor can argue that you said you had a gun and now you are the aggressor for that incident. But I'm not a lawyer. I don't know. But I advise that you do not ever say that you have a gun. The only time they should know that you have a firearm on you is that 1, you're open carrying and exercising your Second Amendment right in an open carry scenario. If you're legally permitted to do that in your state, which here in Colorado you can, except for a couple places. And 2, there's an imminent threat, and you know that you have to shoot them to stop the threat. Okay? With my customers, I advise them never to draw your firearm unless you're willing to shoot them. Never draw your firearm unless you're willing to shoot the imminent threat. That's what I advise my customers. Okay, so I know Mark's going through a scenario here, and I'd like to think he would agree with me. In fact, I'm going to Arizona. I'm going to be talking to them personally. You should go check that out. It's going to be on their channel, and we're going to talk about, obviously self-defense stuff, probably my history, so on and so forth, but you should go check that out.
Fine. Use the least amount of force that is reasonably necessary, even though, the categories of force and deadly force don't really break it down in the law. When you're at trial, and you're arguing to a jury, I want to be able to say my client used the least amount of force that was reasonably necessary, not what the prosecutor is going to want, which is to paint my client as a yahoo, somebody who was excited about pulling out their firearm. You know, as I've often said, if you're excited about pulling out your firearm, you should really think twice about carrying a gun.
I completely agree.
Okay, so that goes back on to the, like, if you cannot swallow your pride, like, do a deep self-evaluation. If you cannot swallow your pride and back off from the situation, it doesn't matter if you are like the biggest ninja, MMA, jiu-jitsu, firearms trainer freaking guy or gal. It doesn't matter, okay? And then the person in front of you looks like this weak, frail individual that, you know, eats Cheetos on the weekends or something. I don't know, right? It doesn't matter. Back off from the situation. Doesn't matter. Just back off from the situation and avoid all that. Deter all that. And then only take action if you have to. And by if you have to, I mean if there's an imminent threat to your or someone else as a third party life or bodily injury, serious bodily injury, right? So, yeah, just back off from the situation, okay?
And there are times where you might be justified in pulling out your firearm and firing a shot, but you choose to do the less lethal option of just displaying a gun. That's a great option if you are able to safely do that in that situation. And that reminds me of something else people do. A lot of people like to fire warning shots.
Okay, so and she's going to get into warning shots in a minute, but what she's talking about is if you draw your firearm. So here's a scenario, okay? Somebody's coming at you. It's an imminent threat. You are willing to fire a shot at them to stop them from being a threat. If you draw your firearm and point it at them and they cease to be an imminent threat, you don't fire. Okay? You're not displaying the firearm. You intended to stop the threat. That's your intent. And then once the threat stops being a threat, you intend not to shoot them. You see what I'm saying? There might be that split second where a threat presents itself, as imminent as it may be. It could be just as not imminent in a second, a split second, which is why there's training that has to happen, okay? Which is why you go to somebody like me, where we can explain these things and we can get you trained to understand what that imminency is, okay? If somebody comes at you with a baseball bat and you present a firearm and they drop the baseball bat and turn around, they're not a threat anymore. If you shoot them in that moment, now you have some explaining to do, okay? Now, you may come out on top, I don't know. But again, you want to avoid, deter, and then take action if you want to. Or not if you want to, if you need to, excuse me.
Get the inclination to do this because, again, you see it as a less than lethal option. And you see it as a way to maybe diffuse a situation without anyone needing to get hurt. Unfortunately, unlike displaying your firearm, warning shots are not necessarily legal where you live. Many states consider...
All right, so a warning shot. Let's talk about this real quick. I can see both the defense and the prosecution argument, okay? And they're going to go over the prosecution argument in a minute. Obviously, the defense argument is going to be, my client didn't want to harm the individual. He or she just wanted to stop the threat. So therefore, they did a warning shot. And then the prosecution is going to say the threat wasn't imminent enough for them to use deadly physical force. So therefore, they shouldn't have fired a shot. And the other thing, like she said, is it may not be legal for you to do that in your state. Again, going back to the 50 states coverage that you can get. You're not going to know every state's laws and self-defense laws, okay? So definitely keep your mouth shut if something happens like that. But you're not going to know. So get your coverage today and use my link. The other thing is, if you fire a warning shot, okay, and it happens to be in a direction where there's a ricochet, and that ricochet ends up going and harming somebody else, or God forbid, death, you're now liable for that person. It could be a civil liability, hundreds of thousands of dollars, millions of dollars. It could also be jail time, prison time, even though you didn't intend to hurt them. So I never advise to take a warning shot. Again, if you pull your firearm, you have to be willing to shoot the threat that's coming at you. Bottom line, you have to be willing to do that, okay? Because as soon as you pull that firearm, it's almost like a point of no return where you're probably or likely going to be charged with a crime, okay? Whether it's, it could be assault, it could be unlawful death, or whatever all the legal terms are, right? I'm no lawyer, like I said. But there's probably a charge out there that you're going to be charged with, right? So if you pull your firearm, you should be definitely willing to shoot the threat that's coming at you, and it has to be an imminent threat.
Shots to be illegal, or they will just not issue a self-defense jury instruction when you go to trial. And that's really important, because if you go to trial on something like an aggravated assault or a murder and you do not...
All right, so this is a very good point. This is a lawyer point that I never really cover in my classes because I didn't even think about this. The jury instruction from the judge, if it's not a self-defense jury instruction, then what the hell is it? That means the jury is not even going to consider self-defense in your trial. So I would, man, that's just scary. That's scary stuff. So, hey, listen, it's about 10 p.m. right now. This is part 1. We're going to do several parts. We're going to get through this video. We're about 15 minutes through the actual video. I've been running my suck for I don't know how long now. It's about 10 p.m. like I said. And we're going to do a part 2 and a part 3 and a part 4, whatever it is. We're going to do all that. And then we're going to put all of them together and do like a whole video, right, of it. We'll put all of them together. But for this one, we're going to stop it here. We're going to come back to it another time. So, do the things like, subscribe, follow, all the things. Also, again, if I beg you, look into the other services. If you like them, go with them. Fine. Hey, thanks for tuning in. If you've made it this far, I appreciate that. If you are looking for coverage, check out AOR. I am an affiliate. I do get paid a commission as long as you sign up, of course, through my affiliate link, which is below, and also in my profile. I believe in their product. I believe that they're going to do what they say they're going to do, and I wouldn't promote it unless I did believe that. I'm not going to promote any of the others because I believe they're more insurance than anything, and I believe that AOR is not insurance. It is lawyers to defend you in the court of law if you have to defend yourself. So check that out. Also, check out my website, www.aaacoach.com. That's www.aaacoach.com, all spelled out. I also have my other socials linked below if you want to check those out. At the end of the day, I want you to stay safe, stay prepared, and stay trained. Tack out.